Okay. Welcome everybody. Now that we are both live on Facebook and everything, I see a lot of people have entered here as well. Welcome to the second session of our IHL Forum book launch series. My name is Rosenzweig. I'm the chairman of ALMA, and I'm very, very happy to have this event tonight. This is the second event we have on our book launch event. Let's see, let's get everything. Yeah, okay, should be better now. As I said, I'm Rosenzweig, I'm the chairman of ALMA. This is the book launch series event that we are having. This is the second event in this series, and we are very, very happy to have with us to host to the book launch of Natia Kalandarishvili-Mueller's Occupation and Control, International Humanitarian Law. This is a very interesting book, and we're going to have a great discussion. We have great speakers, commentators to give their thoughts about different chapters and different aspects of the book. And in a second, I'm going to let Carolina, our coordinator of the forum, to present the speakers. But before that, I would like to say a couple of words about ALMA, and then we're going to move forward. Hopefully, we're going to be brief enough so we'll be able to focus on the book and not about me. ALMA was established 10 years ago as an association for the promotion of international humanitarian law. We have different activities and different operations both in Israel and abroad, and now virtually as well. The purpose of the association is to promote the knowledge, understanding, and discussion of international humanitarian law, and throughout that we have several projects, including this forum, the national IHL competition we do together with the local delegation of the ICRC. We have a lot of articles on the website. We are very active on social media, on Facebook and Twitter mainly, and you're very welcome to join us and also subscribe to our YouTube channel, in which the edited version of this video will eventually be uploaded to. And lastly, I invite you to subscribe to our mailing list, in which you will get information about this kind of events, and also our periodically newsletter, which provide information about recent developments in international humanitarian law. So I'm very much looking forward to hear tonight's discussion. And please, Carolina, could you please present the speakers of tonight?
Hello, everyone, and thank you all for being here with us today. My name is Carolina Grimberg, and I'm the forum coordinator, and it has been a pleasure organizing today's event. I am going to introduce the speakers, and then we'll move forward with the presentation of the book, followed by the input of the commentators. Natia Kalandarishvili-Mueller will be presenting her book, Occupation and Control in International Humanitarian Law. She is a former chief legal specialist in international law of the Ministry of Reintegration of Georgia, currently known as the State Ministry of Reconciliation and Civic Equality. She now is a professor of public international law at Tbilisi Open University and remains as invited lecturer in international humanitarian law at Tbilisi State University. Tom Gall is a legal advisor in the Department of International Law at the Ministry of Justice. She served until recently as an associate in the Golijov Seligman law offices, consulting multinational corporations and litigating complex litigations regarding compliance of corporations with international norms in conflict zones and sanctions regimes. Before that, Tom represented Geneva-based NGO in international organizations, including the Human Rights Council and UNESCO. Tom was also a researcher and teaching assistant at the Geneva Academy of Humanitarian Law and Human Rights. She holds an LLB combined with international relations from the Hebrew University, an LLM with distinction from the Geneva Academy, and is currently finalizing her PhD at the University of Geneva. Emilie is a researcher in international humanitarian law at the Geneva Academy. In addition to organizing the IHL talks, her research focuses on the intersection between IHL and international human rights law. Parallel to her role at the Geneva Academy, she also works as an independent consultant for international NGOs based in the Middle East. Emilie previously worked for 4 years as a legal officer for the Directorate of International Law of the Swiss Department of Foreign Affairs, where she focused on IHL and international criminal justice. Emilie holds an LLM from the Geneva Academy, as well as an MA in Middle Eastern Studies from the School of Oriental and African Studies. Gentian Zyebri is a professor of international law and human rights and the head of the Norwegian Center for Human Rights at the Faculty of Law of the University of Oslo. He holds a bachelor's degree from Tirana University, Albania, and a master's degree and PhD in international law from the Utrecht University in the Netherlands. During his career, he has combined scholarly work with the practice of international law. Thus, he has worked for the defense at the International Criminal Tribunal for the former Yugoslavia for 8 years and currently is a member of the UN Human Rights Committee. Professor Zyeberi's research interests include the contribution of the International Court of Justice and other international courts and tribunals to interpreting and developing rules and principles of international human rights and humanitarian law, the protection of community interests under international law, the operationalization of the responsibility to protect doctrine and transitional justice issues with a focus in the Balkans. So thank you everyone, and we will now start with the presentation of the book.
I'll give you the framework of discussion. First of all, Natia will present the framework of the book, and then we will have the 3 commentators, and after that, Natia will respond to them, and following her response, according to the time that will remain, we will open the floor for Q&A. So, Natia, please, the floor is yours.
Well, thank you. Thank you very much. Let me start saying that I'm very happy to participate in this event, happy to be given the chance. And thank you, Alma. Thank you, Ido, for taking the interest in the book and putting the event together. Thank you, Carolina, for the forum, dear experts, Emilie, Tom, Gentian. Many thanks for engaging with my work and finding the time to participate, and generally thanks to the wider public who found time to attend. So if you allow me to share the screen, I put together a small PowerPoint for the sake of making the discussion easier and kind of putting through the core messages of the book, what I wanted to bring to the forefront this evening. So I'm going to share the screen now. So the book, Occupation and Control in International Humanitarian Law, as you may guess, the book is about humanitarian law aspect of occupation, of military occupation, but specifically what this book tries to do is basically to study the notion of control in occupation law, and specifically to study how we can interpret the notion of control in humanitarian law and what its impact does control have on occupation law. So the book has 4 chapters. The first chapter concerns the anatomy of effective control for the purposes of occupation law. The second chapter deals with the occupation by an intermediary, the so-called proxy occupations. The third chapter looks at the dynamics, the way control is being relinquished over the territory. And the fourth chapter concludes by looking at occupants' substantive obligations from the perspective of IHL and international human rights law. So basically, just to set the terrain and to set the ground, the book really studies the notion of control in light of military occupation and offers the test for examining when is the control established over the territory from the perspective of occupation law, and when does it end. So if you look at the next slide, and obviously everybody knows this slide by heart, and what is very, very problematic in this article, which is Article 42 of Hague Regulations, which is the part of the customary law, is to precisely identify what is a military occupation, and particularly what is understood under the formulation it is actually placed under the authority of the hostile army. What level of control are we talking about? Is it just a control? Is it an effective control? Is it just any type of control? Should we subsume under this understanding overall control, or what level of control? So what my book has tried to identify is to decipher and offer the exact anatomy test of control under what is actually placed under the authority of the hostile army. So the book says that basically it's effective control threshold, and the test that the book offers is basically of cumulative nature. So basically state A's military forces are physically present on the territory in question. This presence is not being consented to by the territorial government. The government of the territory has been totally or partially overcome by state A's military presence, and because of such presence, basically it cannot exercise its governmental powers. And state A's military forces are in a position that they can exercise authority over the total territory or parts of it. So this is a cumulative test. So even if one element is missing, it would be difficult to argue that the situation of occupation exists. So what is interesting is that when you look at the subsequent instruments after the Hague Regulations, such as 1949 Geneva Convention, Additional Protocol 1, you'll see that in Article 2 Common, the consideration that was given by Article 42 has not been really expanded. Neither Article 1 of AP1, offers any additional information. What is occupation, or when should we consider that the territory is designated as an occupied, or let alone what level of control is needed. Now, the other question is that what I offered as a definition of effective control in the book, this comes through as much more as, let's say, a classical definition of effective control. But the wider question is, and the question is, what can be basically considered as the polymorphicity of military occupation? With the current technological fast-pacing developments, with political interests of the states, it's increasingly challenging to keep up with the entire environment, the way the states act, the multiplicity of actors in international law as well. And one other aspect that could signify the polymorphicity of military occupation is that in earlier times you would see just like maybe states acting alone, or just forming cooperations, but much more now it's increasing that you have multinational forces, and importantly, it could be argued that an international organization can also be military occupant. So this said, I also looked at the possibility whether the UN could be considered as a military occupant. So here again, the test that the book offers is basically premised on the previous slide, which offered the understanding of the threshold of control, that was effective control. And for the purpose of examining the possibility whether the UN can be a military occupant, one needs to look at whether the UN mission has been stationed on a territory without the consent of the receiving state. The government authorities have been rendered partially or completely incapable to perform their functions due to the presence of the UN mission. And the UN mission is capable of exercising governmental functions instead of the affected state. Another polymorphicity that could be detected is in the concept of proxy occupations. So this type of occupation is based on the notion of indirect effective control. And here again, the book offers to examine the situation in light of the following test. So you need to have two actors, basically. That's a foreign state on the one hand, and then you need to have an armed group or a de facto local authority. Neither of them is the legitimate government of the territory that is being occupied. And the relationship between the two should rest on the overall control test. An overall control test, I argued in the book, is basically the rests on the same understanding as it was developed by the IC2Y in the Tadic case. And the armed group has to have effective control, as understood in light of Article 42 of Hague Regulations. Article 2 common and Article 1 of AP1. However, the book makes a reservation from the outset, and it says that it doesn't really explore the control of the armed group over the territory. Now, it must be said that the European Court of Human Rights also opined in a way, not so directly, but one can really detect in its reasoning that decisive influence could also, describe the situation of military occupation when the intermediary is being involved. So the legal basis of this test is the notion of jurisdiction as understood in the European Convention of Human Rights. And the basic element is military, economic, and political support that is being rendered by the outside state to the de facto authorities. And so this reasoning is based on the case of Velasco versus Moldova and Russia. Now, another notion that could give us grounds to argue that there's a military occupation, but based on an intermediary, would be to have this notion detected in the case of Loisidu versus Turkey, and this is effective overall control. And this test basically is composed of the foreign states' army's presence on the territory and subordination of local authorities to that foreign state through such presence. Now we just briefly spoke about the necessary threshold of commencing of occupation? And now, what about ending of military occupation? The wider question then is, do these tests match? So when the occupation, when the control over the territory is being established and when it's relinquished, do these tests match? I must say that these, this is a very interesting and difficult topic, because it's not so straightforward, the entire process. The test is not cumulative, as opposed to establishing effective control, OL, over the territory. And the test, as I said, was not cumulative, and either of the conditions could signify that the territory is no longer being occupied as understood by Article 42, Hague Regulations, Common Article 2, AP1, Article 1. So occupation ends if State A's military forces are no longer physically present on the territory. So they can just either willfully leave the territory, or they've just like they were ejected. State military forces are not in a position or willfully do not exercise authority over the total or parts of the territory of State B. And State A's military forces are no longer hostile to State B, as their presence is consented to by the latter. But obviously, the consent should not be bogus, right? However, this is so on the paper. It all seems very nice in a sense that it could be straightforward, but states are finding ways to exercise their control in various ways. And one thing that the book also does is that it basically identifies at least 6 forms of relinquishing control. So this would be, the first form is complete end of control over the territory. This complete end of control over the territory can also happen gradually, like in the case of Afghanistan, when the Soviet Union was phasing out gradually. Temporary or partial loss of control over parts of the territory. That is presumed, the example of Fallujah. Potential for regaining control, West Bank. Control retained after withdrawal, that would be Gaza, example of Gaza. Ending of indirect effective control, that's an interesting one, because in the current practice, this type of example is a bit difficult to identify. So it remains to see what would be the dynamic either in, say, Transnistria, or say in the armed conflict that is now in between Azerbaijan and Armenia. And the 6th form is remaining based on the UN Security Council mandate, Resolution 1546, context of Iraq. Now, the other interesting issue is that from these type of relinquishing controls, what could be identified is 3 types of obligations. So ongoing obligations, that would be with 2 subtypes. That's full ongoing obligations in case there is a full effective control over the territory. Then partial ongoing obligations, they basically flow, like they emanate and flow from partial effective control over the territory. That means that's mostly the case of Gaza, and it's rooted in the functional application of GC4, the idea of functional application of GC4, and obligations commensurate to the level of control retained when the state does not have full effective control over the territory, but nevertheless, it exercises control over that territory from outside. So this is how I could define the partial ongoing obligations. The other type would be the residual obligations, and the context would be World War II, for instance, when not all the POWs were repatriated. The third one is obligations that are based on the past violations, and this is Iraq's actions in Kuwait. Now, the last chapter, the fourth chapter, so the main message of the fourth chapter and what it does is that basically it's looking at what impact does control have on substantive obligations from the perspective of an occupant pursuant to occupation law and human rights law. And it also tries to answer the question whether the extraterritorial application of human rights law and military occupation, they're basing themselves on the same test or not. And what this chapter highlights is that actually IHL and human rights law obligations, they could be triggered through control when you exercise control over the territory and over a person, and also over person's particular rights. And this chapter then also argues that basically both branches could have a situational application. So obligations apply to the extent that the authority and control is exercised by a state's armed force and agents, and nature of obligations then is basically proportional to the level of control that the state is exercising in a particular time or in a particular setting. And the other thing that this chapter kind of tries to shed light on is that basically when a state occupies a territory, the human rights law obligations, so basically not all of the human rights law obligations may have to be provided fully. And basically the state has to do all it can, but there should not be an unrealistic expectation towards the state. And so lastly, to conclude, this is the graph that is basically mapping the various thresholds of control that I identified. And if you look at here, so the gray graphs, they're very much intimately related and connected to one another. And these branches are human rights law and IHL. And basically, what I wanted to say also is that human rights law obligations, they are triggered in times of occupation. But what is interesting is that human rights law obligations, they're just not triggered only because of occupation law. So I guess that's it. This is all what I wanted to say. I hope I gave you the idea what the book is about. And yeah, so over to you, and many thanks for listening.
We're going to go to the commentators, and each commentator is going to be focus on a different chapter in the book. And we're going to start with Tom Gall, who is going to address the chapter titled Occupation by Intermediary. So Tom, you can unmute now.
Okay. So first of all, thank you everyone, and thanks Ido for having me. Thank you, Natia, for this, compilation of everything that has to do with control and the law of occupation. I found it more than, not that I minimize the effect, but just as a starting point of reviewing what the notion of control means and what it has, or what effect it has in occupation, I think that's impressive. Also, the ability to withdraw to other branches or other situations, such as the applicability of human rights law, as well as UN forces, which is very timely in sense of coalition forces and UN forces. So first, let me congratulate you on a book, and on an interesting one that for me obviously is also not just interesting to read, but relates to my research in the past years. So it's been very it's been enriching. So thank you for that.
Thank you for your kind words, Tom. Thanks a lot.
As I wrote to you earlier, I do have some points that I think that I would like, I don't know if to elaborate, to comment, to ask you sort of the questions that led you to address them in a certain position. So I see it more as a dialogue and less of a commenting or remarking. Also, thank you, Ido, for having me, obviously, but that's sort of, it's been years that I've been thanking you, so I'm feeling. So I think what I liked most is that you saw the law being needing to address those kind of situations that we all see them and we're like, oh, that's occupation. That's not just a simple NIAC. And addressing kind of the elephant in the room of what would make such an IAC actually being an IAC and turning into occupation, and the gap of responsibility that exists because of different jurisprudence and decisions of courts and bodies in the international sphere. However, I would definitely want to address that part. I mean, for me, two questions popped. The first one is that I can understand. I think I can understand why it was an emphasis for you, but for me, from my point of view as a humanitarian, it was more like, I understand why there's a difficulty to have the notion of control between the state and the group, and the mixture that has been done in the genocide case and the Guatemala cases versus the Tadic case, Naletilich and Perlich, so the ICTY, but also other criminal tribunals. But as a humanitarian, in the sense of applying the law of occupation, I don't mind. What I would mind is knowing that the state, so I understand the gap of responsibility, obviously, and there's some sort of a gap of protection in the sense that I would not be able to pursue in the ICJ. But recently we've seen so many other paths of making sure that other entities in international law and other actors in international law have been being held accountable for their actions in times of conflict and human rights violations. So I was wondering, why was it so important to emphasize the differences, or to ensure that everyone understands that there's this link between state responsibility and international humanitarian law? Though I can understand the starting point, but kind of like, what was the line going through? And in my personal opinion, why I can see why it is important, I can also understand that I'm not sure that the genocide case, the way it was articulated, and specifically the use of notion of complete dependency there, actually reflects states' practice, but also reflect other decision or former decisions of the ICJ and the way it has been further on interpreted. And I also think that at the bottom line, though overall control and effective control are not the same, they're not that far away from one another. So I can understand the starting point, but I would definitely want you to explain more about why was it so important, this intertwine between the two. And I think my second point, so it's kind of like one of the notions that you've put forward was, especially with respect to Ukraine, is that we have been able to hold armed structured accountable or state accountable for the actions through the chain of command. And I can really grasp that point. But on the other hand, one of the things that bother me is that I know that practically it won't be able to compare a well-structured armed hierarchical form of responsibility or command in a state, and on the other hand, to put as an equivalent to that an armed group that, while it has may have the same interests or the same pursuits as a state, it is not the state itself. So there's an additional step that needs to go there. I would want state to bear that responsibility, but I understand the difficulties. And I think I agree with you. The ICJ decision and the ICTY decisions have made kind of a mess. But while I wouldn't want to be in a position where we compare totally armed groups and their structure to state actors in the sense of drawing the line of accountability. So I would like to hear from you more on that point, and especially of how it would affect outsourcing. So how the state, when the state outsource explicitly to let's say private military companies versus the state outsource to, and I'm using outsource, right, to an armed group like what we're seeing with the FSA, the Free Syrian Army in northern Turkey, for example. Two really short last points. The first one regards the emphasis that you've put on. I can see why it's. I think that it's important to differ between de facto authorities and armed group. They're not the same. A de facto authority is not a militia. It's something more. From my perspective, and I think it's kind of a question, I think most, if not all, the examples that you provided were a situation whereby the state itself already had boots on the ground and then sort of withdrew or lowered the extent of its control and established something instead in its place, like taking its own place, while in most of the cases that you referred to in armed groups, then that was the armed group operating and the state kind of backing it up. I think the only case that I can see sort of overlapping is the Georgia case, where you have areas of Abkhazia and Ossetia that are fully controlled by the militia being backed up by Russia, and then other areas that were first invaded by Russia and then withdrew or left behind several troops. And I was wondering, why was it so? Why, in your opinion, and it really intrigues me, why, in your opinion, it would trigger, you would need to trigger that intermediary test, that overall and effective control, while we know that at least at the stage of the invasion, sort of like referring back to France in the Vichy regime, it's kind of obvious. It was already, so I understand the difference, and I understand why it's important to address it, but I would want kind of an emphasis on, I was wondering what was the emphasis on having also sort of a test of control there. And last comment, thank you for sharing the SDSL decision judgment on applicability of occupation in NIAC. It was, for me, that was a great read, like going back to the SDSL and then compare the jurisprudence, how it's shifted throughout the years on addressing occupation, the term occupation and non-state armed groups. So I really appreciated that short but very concise line in your chapter. So thanks, Natia, again. It's been a really good reading, and I'm looking forward for your sort of answers, remark, dialogue, or whatever.
Thank you, Tom. Okay. So now we're going to go to Emilie with the chapter 3, comments on chapter 3, relinquishing control over territory. I think you can
unmute
now.
Good evening, everybody. I'm very happy to be here and very honored and very excited to participate. So I would like to thank Natia for sending me the book and giving me the opportunity, and Alma for inviting me as well. I'm especially happy also because Tom Gall was one of my teachers when I was an LLM student, so it's an extra honor to share the stage with her tonight. And full disclaimer, it's also the first time that I'm participating in a book review, so please be kind. And I also see this as an opportunity, a learning opportunity for myself, which adds to the excitement. So first, I'd like to make a few general comments about the book itself, and then I go to the substance of the chapter. So like the rest of the book, and I've taken sneak peeks at the rest of the book, I really appreciated that chapter 3 was well structured and well written. This didactic aspect, you know, it's formal, but I appreciated it because it allowed to follow the author's train of thought, so it made for a nice read. And chapter 3 also aims at being as practical as possible, notably by developing a test for establishing the end of effective control, a test that Natia has presented before, and also by providing real-life examples. And I think this is, key to the practicality and also the quality of the book. I know Tom questioned it, but I really appreciated the fact that Natia was very clear in specifying the terminology that she was using, so making clear distinction between effective control for the sake of occupation, or effective or overall control for the sake of state's responsibility, or for the sake of establishing human rights jurisdiction. It's easy to get lost with the terms, and the book makes sure that we don't. So that I love. On substance, Natia gave an overview, I think, quite substantive of what the chapter goes through. And there are a couple of points I want to focus on. So as mentioned, the author develops a test for determining whether effective control has been relinquished. So whether actually the occupation has ended partially or in full. And one of the criteria, actually the first one, puts a lot on emphasis on the end of physical presence of military forces on the territory. It's also a criteria that she has taken up for establishing control in the first place. I think the question of, are boots on the ground necessary for the sake of occupation, is one that remains in the field and has remained for a long time. The author had taken a clear stance on it, and I think that's to her credit. I don't necessarily agree with it. I'm more, you know, my personal view is a little bit more flexible, but I think it's always brave to take a firm stance on those things. What I appreciated, however, was that the issue is a little bit nuanced later on, for the sake of applicability of GC4. So what I mean is also what Natia mentioned before, is that she establishes and proposes a sliding scale for phasing out the applicability of GC4. I think it's the phasing in of occupation and the functional theory of occupation is something that has existed for a while now, for establishing occupation for the sake of Article 42 versus scope of ability of GC4, and the fact of doing it on the way out, I think is smart and practicable. Where I would nuance that a bit is, in my opinion, I think that GC4 applies until the occupation fully ends. So for me, until the phasing out phase is ended, the occupation hasn't ended yet, even if control is not fully established, but only partial. And that's where it's important to see whether, you know, what capabilities the occupying power or proxy still have. And with that, my personal view is also that Gaza remains fully occupied, and that therefore a GC4 is still fully applicable, although I understand the importance and the reasoning behind saying that only certain kind of obligations apply to Israel in Gaza with regards to GC4. But I think this difference, recalling the fact that Hague regulations and GC4 have different scope of application, Also, different rationale is something that is nicely done in the chapter. What I would like maybe to hear Natia a little bit on is the consequences of the different scope of applications, also in terms of choices and in arguments that lawyers can choose to put forward in favor of the author's position or maybe against. The next point that I would like to underline is, so after explaining, presenting the test, Natia presents various forms for relinquishing control, which she has already highlighted, but by way of reminders. So the categories that she analyzes and proposes are the following: complete end of occupation, temporary or partial loss of control over parts of a territory, potential for regaining control, control regained after physical withdrawal, and end of control through an intermediary. And I had a few questions with regards to the second category, so temporary or partial loss of control over parts or territory. The example that she uses is the West Bank, and the argument goes as follows. Israel and the Palestinian Authority have concluded the Oslo Accords, which divide the West Bank into areas, and with different areas come different responsibilities for each of the actors. So area A is full, control exclusively by the Palestinian authorities. B is mixed control, and C is full Israel control. What I missed from the chapter, and would very much like to hear Natia on, is the impact of Article 47 of GC4 on her conclusions. So, in other words, does Article 47 of GC4 mean that the Oslo Accords have actually no impact on the applicability, at least, of GC4? So, if you take Article 47 into account, does it mean that Israel has actually partially lost control over area A's and B's of the West Bank? Or does Article 47 means that the division made by Oslo is actually null and void for the sakes of establishing that the West Bank is still occupied under international humanitarian law? And then I have, two last remarks that are, I think, a little bit broader. The first one is that the content of Chapter 1 and Chapter 3 made me think about the overlap of the book's topic with the issue of temporal scope of applicability of IHL. So what I mean is that determining whether control has been established or relinquished over a territory to determine whether it is occupied aims in the end at determining whether the territory is occupied and whether GC4 and Hague regulation, and to some extent AP1, also applies to that territory. So isn't it the same exercise? Or if not, why and how? And so, yeah, I think I would like to hear Natia's thoughts on the overlap between those issues. And I also wanted to say that Julia Grignon has published a book on temporal scope, and she has 2 chapters on occupation, establishing temporal scope of beginning and establishing temporal scope of on end. And I think it's a nice complement to Natia's arguments. So I missed it a bit, references and maybe critique, I missed them from the book, but it's due to the fact that unfortunately French and English, unless you're bilingual, arguments don't connect. And yeah, and it's the problem with language silos in our field. But I think for students, if they're being taught by someone who can speak both languages, the comparison would be interesting. And lastly, I would like to, and I think that's the last point I had written down was consequences of different scope of ability of GC4 and Hague regulation for the phasing out and the consequences. So yeah, those are my humble thoughts, and I look forward to hearing Natia's comments on them. Thank you so much.
Thank you, Emilie. Now we're gonna ask Gentian to provide his comments on the fourth and final chapter in the book, which is titled The Effects of Control on Substantive Obligations. Please.
Yes, thank you very much. And well, first, let me thank the organizers, ALMA and Mr. Rosenzweig. I think I'm going to move on a first name basis with everyone that is participating in this panel. It's a great possibility to participate in the launch of this very important, very good book on a very important topic on issues that are, I think, quite complex and difficult. And I want to commend, of course, Professor Kalandarishvili-Mueller on engaging with them in a very good, thorough, concise manner. So, and I also want to commend her for visualizing, for including all of these figures in the book, because it also makes things a little bit easier to follow the dense analysis that she has provided. So I will limit my remarks to chapter 4 on the effect of control on substantive obligations. And I want to highlight some of the main points that she has made in this chapter, and then offer some critical remarks on some things that should have been included or maybe could have been included. So I'm going to push her a little bit on some of those. So the analysis in the fourth chapter is structured around 4 main sections. And of course, all of these are huge issues that she assesses, analyzes, I think, in a very concise manner. So in the second section, she's dealing with occupying power substantive obligations from the perspective of IHL. Third, whether control is construed in the same way in human rights law as in occupational law. The fourth one on the contextual approach to state obligations, and the fifth on the inter-application of humanitarian law and human rights law. So she starts section 2 by pointing out that occupying power substantive obligations in IHL are not as extensive as in human rights law and can be divided into obligations vis-a-vis the displaced sovereign and those towards civilians. Here she takes issue with a notion which is used a little bit more often, that is that of functional application. She suggests a new term, if you want, situational application, when it comes to the beginning of belligerent occupation. And I would tend to agree with her because whenever I hear a functional approach or a functional application, then immediately my thinking is about the application of the law and the aim and purpose of the law. So in a sense, I take this suggestion that she has on board. In the third section, she analyzes whether control is construed in the same way in human rights law and in occupational law. And then she focuses on, in terms of control and authority over individuals and control and authority over territory. And with regard to control and authority over individuals, she concludes that both human rights and humanitarian law recognize control over persons, and both human rights and humanitarian law ensure that persons' rights are protected when members of the armed forces or state agents more generally exercise control over them. When it comes to control and authority over territory, then she concludes that in the case the state is a military occupant, then the threshold of effective control over territory alone would suffice to give rise to the application of IHRL. Once occupation is established, then the full spectrum of human rights law is applicable. By contrast, the effective overall control test may be conceptualized as a two-tiered test where overall control over a group or entity gives rise to effective control over the territory. And I'm just giving some snippets actually that I have taken from these different sections because of course the discussion of analysis is very rich. Then moving on to section 4, the contextual approach to state obligations. Then here, of course, based on the whole analysis that builds over the different chapters, she summarizes to a large extent by saying that the provided test triggering the application of human rights and humanitarian law obligations may be seen the test of effective control over persons, particular rights, and the test of the situational application of Geneva 4 are equivalent, since both deal with specific rights. And she rightly points out there that the all or nothing approach to applying human rights law instruments would have a pernicious effect on those who necessitate protection and release the state from its obligations, arguing that because it was not in the position to provide all some obligations, it had to ensure none. So I'm not quite sure that that will necessarily stop states from evading responsibility or trying to evade responsibility, but I think it's a point that's well made. Then in section 5, just before concluding for this chapter, she deals with inter-application between human rights and humanitarian law. I have to admit that this inter-application and the relation between human rights and humanitarian law has been subject to a lot of literature. There are probably by now libraries written on this issue. She can only address this in a limited and a concise way. And I have maybe some criticism, but I'll get to that in a second. But first, she suggested the best approach to be adopted appears to be one which is geared towards interaction of these two branches rather than substitution or simple addition. And interaction here would mean that rules from one branch inform the precise application of the rules from the other. And this would seem to me to go more towards, of course, the complementarity or a complementary application, if you want, with the aim to ensure the highest level of protection, or at least that's how I have understood it. But Natia, of course, will be able to tell us if my understanding is necessarily correct. Then this, of course, works both ways, this interaction. It can be that an IHL rule can be used to specify a human rights rule, or the other way around. And then when it comes to having a more general framework, then she's referring to Derek Murray's book, and there first, under the active hostilities framework, IHL provides the primary point of reference, and IHL is applied there, and human rights is applied in the context, and the security operations framework, where human rights law is the primary point of reference and IHL supplements it. So if I turn on now to some more critical remarks, and I have to add a caveat here, of course, because I understand very well that the book's focus is on occupation, control, international humanitarian law. So some of my remarks here are offered more as an invitation to the author for another book where she can expand on this, or eventually the need probably for a little bit more nuance in dealing with some of the issues. So I have 3 areas where I want to ask her to provide a little bit more explanations. The first one concerns socioeconomic rights and their place in the analysis. So in the second section, in section 2.2, in this chapter 4, she tries to go a little bit more into the substantive obligations, but I'm not quite sure if that is sufficient, actually, or if she goes sufficiently into this. She makes references to several substantive rights falling under socioeconomic rights, but then I'm missing some more in-depth references to the Committee on Economic, Social, and Cultural Rights, concluding observations, or general comments. Then there are references, of course, to the Human Rights Committee's work, and we also try to grapple a little bit with these issue of control in our own case law, and we have actually quite vivid discussions whenever we speak about effective control. Everybody gets quite fired up. But in any event, I would have loved to see here maybe some more references perhaps to General Comment 36 on the right to life, a number of the paragraphs, especially those that are in section 5 of General Comment 36, where we speak about the relationship of this right and the CCPR to other international law areas. Maybe the Human Rights Council here might have also been another source maybe to draw upon, especially the Universal Periodic Review of some of the countries. But in any event, that's maybe a little bit my human rights take here. And since we are in session of the Human Rights Committee, all of these things just come rushing through. Then when it comes to the interaction of human rights and humanitarian law, then I think the way this interaction is construed, or at the beginning, I think could have used a little bit more nuance. I agree with the general gist of what she says, more or less. But when it comes to this interaction, substitution, or addition, then I think there is some writing there, especially an article by Daniel Bethlehem, which outlines a little bit more ways of interaction between human rights and humanitarian law. And of course, there are lots of writings. And the caveat that I wanted to make before is that it's easy to see some of the shortcomings maybe in some of the work when it comes to using more sources. But if I turn that against myself, I would have loved to have read the book actually before I submitted a chapter on this issue of control a few months ago. So again, you cannot probably take all of these issues into account. The last thing here, when it comes to the interaction, is the analysis of ICJ's case law, which has been subject to a lot of analysis by different authors. And of course, the three references are to the cases, to the two advisory opinions, nuclear weapons, the wall, and the armed activities case. And this whole discussion about lex specialis, lex generalis, and the interaction, the three scenarios, only IHL regulates, or only human rights, or both. I think it's good as it is stated, but also have to keep in mind that these three cases are dealing with three completely different issues in a sense. One with the use or threat of weapons of mass destruction, the other one with a situation of partially with occupation, but also a number of human rights and IHL obligations related to the building of the wall, and the armed activities is related to the occupation by Uganda of part of the territory of the DRC. So, but again, as I said, I am overall agreed with the gist, but some more nuance. The last point relates to the focus in the book is, and rightly so, I would say, I would freely admit, on treaty law and treaty norms. Then I missed some references to customary IHL, maybe to customary human rights law, and then my question to her would be, which one of these norms could have been discussed, where would we find them, and how, or to what extent she would be able and willing to use customary international law norms in the analysis, and whether that actually would change anything in the whole discussion. So these were some general remarks, and I'm looking forward to further discussion. Thank you very much.
Thank you, Gentian. And now I'm going to invite Natia to respond to the speakers, to the commentators. Please, Natia.
Well, actually, I had a quick thought. I think I'll just go and climb a Kilimanjaro and then come back. And then, that would be my response, because my head is spinning. And it's just like, can I just really thank you all, because you took so much time, care, and, you just like engaged with my work, and thank you very much, because these comments are to die for, and I'm really grateful, really grateful. I don't know where to start, so if I derail, or I'll try to do my best. Please be nice, or I just have to go to Kilimanjaro, or but with the lockdown. But I think it would be easier for me to find the ways than to try to pack the answers. But let me, may I just start with then chronologically, and I would start answering Tom's questions with regards effective and overall control test. I agree with you with regards this, and I think it's a huge tension. It's a huge tension, and I hope it can be resolved at some point between the two camps. I think everybody has their own take with regards to this, and I just think that overall control test is more practicable, more robust in its application, and it just like realistic. It's a realistic benchmark to make a third state accountable, both for its actions in a prima facie non-international armed conflict, as well as in terms and from the perspective of state responsibility. The thing with the whole setup, so how to and why would we use, if I understand you correctly, the overall control to assess whether there is a proxy occupation? I think again, it's a wider exercise of the conflict classification. Obviously, states try and use armed groups for various purposes, and I think that was, in a way, it just like logically led me to delve deeper into the interaction between the two tests, and then choose a overall control, because any which way, since I kind of came into contact with IHL, I always thought that overall control was more realistic, even for the state responsibility purposes, in light of Article 8 from ARCIWA, that is interpretation of the ICTY, the Tadic line, as opposed to Nicaragua and genocide cases. So I think it was just the part of the wider conflict exercise, because the book dealt with the issue of control. And then because in a generic sense, non-international armed conflict, to use Dinstein's words again, does not really recognize the architecture of the non-international armed conflict does not recognize occupation. Yeah. So what to do when, for instance, a third state exercises territorial control through an armed group, So, or thanks to that control, the armed group controls the territory. So we could go both ways, right? And then the book says that it's just focusing on the relationship between the third state and the armed group or the de facto authorities. The differentiation between the de facto authorities and armed groups, it's again based on the practical case example that was available, and that I kind of, started to differentiate, because obviously there is a difference between the armed group and the de facto authorities. So then where is the fine line? And I do agree, it's, so when does the armed group cross the threshold of degenerate or become de facto authority, right? Like what are the characteristics? What's the fine line? Or maybe, so de facto authorities are like state-like entities, obviously, right? But what I could observe during working on my PhD, as well as then, transforming the work into a book, is that if there is no involvement of the third state, irrespective of any entity, be it an armed group or a de facto authority, they can't really pull themselves alone. They can't really achieve their goals. It's really, really scarce. The examples are scarce in this regard, because always they need they need something more to either enforce their aims, or they just remain at the threshold of non-international armed conflict in the best case. Regarding the outsourcing, this is a very interesting question, and I must admit I did not really think about it. Obviously, I was thinking much more in terms of straightforward examples, but outsourcing this or that way happens in those examples that we have seen, right? Even when, for instance, the dynamic, every armed conflict, and especially situations of military occupations, they're not really the same in their characteristics, because it's always the changing terrain, let's say, like this. So it's an interesting topic, obviously, and outsourcing would, in my understanding, still generate responsibility, and it would still, but then outsourcing on what level? On a contractual basis, like in type of armed conflicts where the group Wagner is being sent, right? Or just like armed groups say that what the situation in Libya, the unfortunate situation when the migrants are being held in very bad conditions, and then who's responsible? The armed group is having their outsourcing of certain tasks, with smuggling them over and etc. So this is what comes to my mind now. I hope I kind of answered around the raised issues. I just would add, with the situation of the tension between effective control and overall control, I know that I'm not maybe taking the popular view. I know, but I'm just like a lawyer. I just think that the law is there to serve the weak. Okay, the law is there to protect the most vulnerable, and the rationale behind IHL is that it has to get to those who need it. And I think if we're letting the states off the hook time and again, and not bringing them in front of the let's say in front of the international community, and telling them, look, you violated this and this and this pursuant to international law obligations, say in light of IHL, then I think the whole idea of having international law is futile. I think effective control and this complete dependency. Okay, I agree with complete dependency, that there is logic to complete dependency that is couched in Article 4 of the RCWA. Okay, I understand. But when it comes to, because it's state organs, equating state organs, so de facto authorities, when you want to equate them, pursuant to the ICJ logic to that bench, it will never happen, because you need so much factual evidence. And I think it's, yeah, it will be lamentable if the international community continues on that road. And I think if overall control test is just practicable, it's more honest in its outlook, and it's just geared towards, you know, affording protection and making this or that state responsible for certain actions. So yes, I do regard that overall control could be a good test, both for establishing prima facie NIAC to become an international armed conflict, and also establishing state responsibility. However, I acknowledge that I'm walking on a very, very, let's say, unpopular line of argumentation, but this is how I think. And yeah, so, and to go over Emilie's questions, to go over to Emilie and try to answer her questions. Yes, I just, because, like, to start from the boots on the ground, if I may. So if I correctly remember, just scribbled. So boots on the ground. So when I was looking at this criteria of what makes a state an occupant, so examining Article 42 Hague regulations, this is all what we got at this point, right? And it has been throughout these years, and it came like this. And unfortunately, I would have wished, or maybe this isn't a topic wish of mine, that something much more could have been added to the Article 2 common, to maybe you know, expand more on the possible scenarios of occupation, like when they said that the occupation could also happen without armed resistance, right? But then again, that was based on the time that was after World War II, right? And then in AP1, nothing really changed. So in so far what I had dealings with, and so far what I had research done, I could identify that, you know, the definition did not really progress to a to include more complex scenarios, not to take into, well, about the self-determination and, you know, the AP1 Article 1 addition is great, and I think it's a welcoming addition. However, from the perspective of the way the law stands, it is very difficult to argue otherwise. But as you pointed yourself, Geneva Convention 4 gives you the possibility of another avenue for its application, right? So it just gives you, it ushers you down to another possibility, and kind of puts this protective bubble still over the persons in terms of making certain provisions of occupation law applicable to the protected persons, provided the protected person matches the definition of Article 4 of GC4. And yeah, it's just like, I also think, and maybe this is a topic, and maybe we just need a follow-up clarification, another additional protocol, which would acknowledge the fact that, okay, there are situations where you need boots on the ground, but guess what? There are situations where you may not need boots on the ground. But then the problem would be that how easily would the states be on board? How would the definition fit every situation? So where's the fine line between the existing understanding of Article 42 and then the current situation? So I think we need to use all our current resources that we have, and I think Geneva Convention 4 is very well capable of handling this situation. So in terms of offering a more flexible level of applicability based on control, on situational control, and on sliding scale, so functional, so revolves around the same understandings. Yeah, with regards West Bank and Article 47, if I correctly recall, so cut me if I'm wrong. That's a very interesting question. And I looked at Article 47 in terms of Ukraine and Georgia. And I must admit that, so Article 47 is a very powerful tool. So if you couple Article 47 from GC4 with Article 7 from again GC4, so just to make sure I'm not speaking, yeah. So Article 7, special agreements, and then 47, the same. So I think that the situation in the West Bank and Gaza generally, it's a very complex case, very complex case, and I must admit that it was overwhelming information, and at some point, as Gentian mentioned, you need to kind of orientate yourself to get across your message, I think. So yeah, and it doesn't mean, so I think, so it doesn't mean that annexation does not exclude occupation, okay? So occupation could be there, and so annexation could happen, right? So the beauty of this article is a very, very robust article in its application, and I think the drafters did a very good job in having this inside. So I think this is like, I just think that now the areas are divided, right? So the international community thinks that it's occupied, right? So the areas are being divided, and some tasks were transferred to the PA, right? So now my logic and thinking is, how are you fitting, how are you fitting this transfer into a classical understanding of Article 42 of Hague Regulations? How are you fitting? And this is it's a complex one. So it's a complex one, and so how could we fit? And occupation can come to an end when actually also there's a scenario, and I did mention it in the book, that when you transfer the governing over the territory, right? It could signify, and then it could signify that the occupation is over. So it's a fine line. It's a fine line case. I admit it's a fine line case, and I think I tried to look at the facts, because I think IHL applicability is premised on facts. So if the facts match what we have as a law right now, yeah, then we need to argue around this. I mean, I don't know if I answered your question. I hope.
Well, yeah. I would love to elaborate further, but you did, and you still have to address Gentian's comments.
Yeah.
I would love to keep this going.
Yes. Yeah. So, yeah. With regards, so if I may, then I move to Gentian's comments and. Oh, where do I start? So where do I start? Yeah, socioeconomic rights. This is something that I really would like to explore further. And at some point I really had to like orientate myself around the entire idea of this control. I had to massively cut down because I had, I had to take one entire chapter out of the book, as well as cut down on the text and etc. So economic, social, and cultural rights, this is something that I would really like to explore further, and in times of occupation. That's a very nice tip, and thank you very much. With regards to the interapplication, I think the whole idea. So I just like control can trigger situational application of the law. And I think the rationale behind the fact that human rights law applies at all times and IHL applies in specific scenarios. So this is where I was basically revolving around. And my understanding of this interaction is based on this, on the concept that both branches can have a situational approach to their application. So extending their application based on situations or based, so according to the situation. And this whole conduct of hostilities model and human rights model, I think it's, again, it relates to my previous comment. I think I don't know if I missed one question with regards Emilie's question with temporal overlap. I'm sorry, it just came to my mind. But I just to keep this in mind. So I think the interapplication of the two branches, it's a very complex topic, and further research is maybe needed, much more expanding the responsibility of states through various human rights law instruments, and how would that say bode, and this is again with your line, with the longer the occupation lasts, the more shortcomings of IHL could be detected. And this is, where I think that IHL could, learn from human rights law. So I just kind of view this in this angle. I'm sorry I jumped from this to this question, then to Emilie's question with the time frame. And there's some comments in the chats, but I can't really check what's going on. So if somebody wants to read, I'll be more than thankful. So but just to focus on the question given, that's a very interesting topic. And then I would just about the time frame and overlap. And so basically what I'm suggesting in the book, and maybe that's how to say, not directly answering your question, because I'm just focusing really on the elements of control, right? So I'm just studying how does humanitarian law comprehend in times of military occupation the control. It could be the indicator, right? So when you establish the control over the territory, it can be an indicator that, you know, it's not that it can be, it's an indicator that you've got a situation of military occupation. Based on the test that I just formulated. But then the wider question is, when does really occupation come to an end? When? So do we need a peace treaty? Right? How do we define what's the future of the territory? So one thing is to, the indicator would be that occupation is over when you relinquish the territory, the control over the territory, right? So that means that it is intimately connected to one another, but I think it's a whole different, you know, it's a different topic in my understanding, because then you also need to look at the peace treaty. This is my understanding, you know, and how could you mark the end of occupation? How do you mark the end of occupation? So. And then we don't really have the time frame. The time frame is not given. So Article 3 in AP1, it uses this formulation, termination of occupation, yeah? We've got Article 6 in GC4 that uses a 1-year rule, right? Yeah, and then it's just like a little bit of, you know, a little bit of fine line in arguing when do we really have the termination of occupation. In my understanding, that would be when you relinquish control over the territory fully, right? Then you're absolved from all the obligations in light of Hague regulations and Geneva Convention 4. But obviously the peace treaty would be also something very helpful to look at. So this is how I would approach my answer to your question. I don't know if I answered. Yeah, so forgive me if I was too long, but I just got because I just don't know which question to answer and this, yeah, so. Okay.
Thank you, Natia. We are borderline with the time frame we've set to the event. So I'm gonna just refer to one question we had on the chat, and I'm doing that mainly because the person asking the question is a member of ALMA, so we do give some preferences here to our members. And she asked me to read it on her behalf. Regarding Article 47 of the Fourth Geneva Convention, it is both to Emilie and Natia. Wouldn't Emilie's interpretation call for a paternalistic application of international law? Couldn't the parties themselves reach an accord as to the status, such as the end of occupation?
Can you, I'm sorry, repeat the question, because I did not really understand.
Of course. Would Emilie's interpretation of Article 47 would call for a paternalistic application of international law? Shouldn't the parties themselves resolve the situation, for example, by reaching an agreement of the end of occupation?
If I may, and then I'm hoping that Natia will complement. No, I'm very grateful for the question. My answer would be the following. I think the point of Article 47 and the beauty of it is that it doesn't prevent parties to the conflict meaning the occupying power and then the occupying state or other authorities, to reach an agreement that would put a formal end to the occupation. In my view, what Article 47 does is that it provides safeguards for the rights of protected persons, specifically in the occupied territory, because it is considered that occupation is a situation that puts them at specific vulnerability in the hands of the occupying power. So what Article 47 does is that it puts a limit on the substance of what the agreement can be, unless it's an agreement that can be considered a peace agreement or an agreement that formally puts an end at the situation of occupation. So I have Article 47 here, and it said, protected persons in the occupied territory shall not be deprived in any case or in any method whatsoever of the benefits of the convention by any chance introduced, shall not be deprived from the benefits of the convention by any agreement concluded between the authorities of the occupied territories and the occupying power. So again, it doesn't say that they cannot reach an agreement. It says that it puts a substantive limit to the content of the agreement in the sense that it cannot impact the rights of protected persons. So for me, if you consider that, this is a paternalistic approach, then it means that IHL as a whole body of law is paternalistic, because what it basically does, it puts limits to what parties to conflicts can do. And to answer your follow-up question, my point was not to say that the Oslo Accords had, as a result, saying that Area A is not occupied and that protected persons do not benefit from GC4. My point was, I don't believe that the Oslo Accords mean that Israel has lost any kind of control over Area A or Area B, for the sake of Natia's argument and Natia's book. So for me, the West Bank is not a case of partial control. So that's it.
Natia, do you want to add anything?
Briefly? Sorry?
Briefly.
Oh, it's a hard thing. No, but I agree with the first take, but obviously I have my own view with regards Oslo, right? So, and as I said in the book, so it just like, for me, this example is interpreted like this, so, and I think it's, yeah, so I think.
Okay, so I think it's a good place and a good, interesting point to end this discussion and actually introduce your next book whenever that will be ready, because I think you've had here enough material for at least one more book on occupation and control and human rights law and Article 47, all that framework. So I want to thank Natia, I want to thank the commentators, Tom, Emilie, and Gentian. I want to thank Carolina for helping us organizing the event. The next session of the IHL Forum book launch series is going to be on November 23rd, when we're going to discuss the book Ensuring Respect for International Humanitarian Law, which is an edited volume. The editors are Eva Masigenham and Annabelle Mekonaki. Hopefully I pronounced that well, but as I think all speakers here know, we actually have issues with pronouncing names. And that is going to be actually the most global event we've ever had, because the editors of the book are in Australia. Some of the speakers are going to be from the US, some of them are from Europe, and we are going to moderate it from Israel. So that's going to be an interesting time zone challenge to find the right time and the right place. It is going to be on November 23rd, and I invite you all, of course, to join, to subscribe to our mailing list, to follow us on social media. And I want to thank again the speaker and the commentators, and of course, Natia